Let's now go on to the phone lines and speak with Isaac Wilberforce-Mensah. He is a spokesperson for the Attorney General and Minister for Justice, Godfrey Dame. Isaac, thank you for your time. You're welcome to Newsbeat. Good afternoon.
Thank you very much, Annie. It's definitely nice to hear from you again, and a big good afternoon to all your millions of viewers worldwide.
Right. So we've heard the AG from yesterday defend himself since he's been blamed for allegedly doing some little to overturn the ruling or maybe ensure the payment of the judgment that was awarded at the time. What exactly is he seeking to achieve?
Well, let's take the two arms that you just mentioned right now. Doing little to overturn the ruling and also doing in respect of the payment, ensuring payment. So I'll just touch briefly on ensuring payment. So that one definitely is not the AG's responsibility. That falls clearly within the corridors of the Ministry of Finance. Now, doing little to overturn the ruling with the greatest of respect, this is, maybe I'll just take some time to explain this really briefly as well. So this is an arbitral award. Now, unlike litigation where one person drags you to court, whether you are willing or not, this is an arbitration award. An arbitration award means that both parties willingly submitted themselves to this arbitration process. And what that means is that the award given, or the judgment, the judgment given is called the arbitral award, which is a final award. Now, a final award cannot be challenged at all. It can only be challenged under limited conditions, including where you can establish fraud, or you can establish that the arbitrator was known to the parties, or the arbitrator had interest. The arbitrator had interest in the matter, and the arbitrator did not disclose, amongst others. So there's a very limited scope to challenging an arbitration award. So if it doesn't fall under any of this scope, any of these conditions stated, or the conditions for challenging an arbitration award, it remains final. So what has happened is that an arbitration award that was given as far back as January 2021, which precedes Honorable Godfrey Dame becoming Attorney General. Right now, what's happening in the court, or what happened in the court quite recently, is not a new judgment. The $111 million is not a new judgment. It's an attempt by the judgment creditor, the GPGC, to enforce the award that they had obtained as far back as 2021. So that point needs to be made very clear. And also, just doing a little bit of math, the story out there that Ghana has paid a little over $1 million since the $134 million judgment that was given, or the arbitration award that was given, may not entirely be accurate. Now, I don't seek to hold beef for the Ministry of Finance in respect of how much that has been paid so far by the government of Ghana, but it's abundantly clear that if the judgment was $134 million and $1 million or almost $2 million has been paid, you can't have $111 million. So clearly, the government has made some clear commitments or has made headway in respect of the payments that have been made. But going back to the record, the issue of the Attorney General's role amongst others, this Attorney General, in respect of issues of judgment debt, has proven beyond doubt that he has saved Ghana a lot of money in respect of judgment debt, and he has even earned some money for the country in respect of judgment debt. So in respect of this particular matter, the GPGC award that was given in 2021, which precedes Honorable Godfrey Dame, I think it's an unfortunate attempt to rope in somebody. When I say somebody, I mean the Honorable Minister for Justice, somebody who has done a lot for Ghana, to rope him in this matter when clearly it hasn't got much to do with him, save the fact that there has been an arbitration award which has to be paid. Arbitration award is final. Now, the absence of or Ghana not being represented in the court, as is also being put out there, the clarity is that you need the court, unlike regular arbitration where you do not need a license to appear for Ghana, when it comes to arbitration, when it comes to the United States, for instance, you need to be licensed to practice in the United States. So it means that Ghana would have had to cough out more money to engage foreign counsel to go and stand in court to say that there is an arbitration award and there is no challenge to this arbitration award, or we don't have anything that falls under the limited conditions for challenging this arbitration award. The arbitration award was given 2021. The arbitration award is final. There's a limited time to do certain things, post the arbitration award, and the finality has been established. So it's up to the finance ministry to make payments. And from the math I did earlier, it's evident that the finance ministry has indeed been making payments in respect of that.
So how much has the finance ministry advanced so far?
Like I said, I do not hold brief for the finance ministry. I can't speak to the figures that they have. But what I can speak is just basic math, and paying less than $2 million out of $134 million would not leave $111 million. So clearly, the amount outstanding is $111 million, which indicates to me, with the basic math I learned from PSEC, that some monies, more than the $1 million, as is being put out there in the media, has been forwarded to the judgment creditors.
The judgment debt that Ghana incurred was $134 million.
Absolutely.
Now, this also in our failure to pay led Trafficura to secure a judgment in U.S. courts which imposed a mandatory interest of $111.4 million. That's separate from the base judgment debts that Ghana incurred.
No, that's not the case.
What's the case?
The interest is not the interest of $111 million that has been imposed. It's the $111 million, to the best of my knowledge, to the best of the briefing I've received so far, is what is outstanding in respect of this same $134 million that was awarded to the judgment creditor in January 2021.
How is that? How do you explain that? This is someone who has been trying, or a company that's been trying to redeem its money from Ghana as far as judgment debt is concerned, and we have failed to do so. And the company has gone to court again to secure us, to force us to pay.
No, the company, no.
So what are you doing a deduction? Hold on. Are you doing a deduction of how much Ghana have paid from the $134 million, which was the earlier judgment debt we incurred in 2021?
I'm saying it's up to you to deduce. As I see the math, paying that amount of money, what happened in court in the United States was not an arbitration, was not to force. It was to enforce. So to enforce a judgment is a legal term. To enforce a judgment is something that you already have the judgment, and then you're seeking to enforce the judgment. So it's a bit different. So what happened was that they sought to enforce the remainder of the amount outstanding from the $134 million as was given as the initial judgment in January 2021.
Okay, so are we saying that the Attorney General, we are actually trying to disassociate Godfrey Dame from the position of an Attorney General? And are we saying that if he has assumed this office, Ghana do not have a capable Attorney General who would, defend the country in cases of this issue, per your earlier explanation? Is that what you're saying?
What I'm telling you is that Ghana has a more than capable Attorney General. In that, if I ask you, Annie, right now, mention one judgment debt case that has gone against Ghana since Godfrey Yeboah-Dame became the Minister for Justice.
Of Godfrey Yeboah-Dame, hold on. We're not talking of Godfrey Yeboah-Dame. We're talking of Ghana's Attorney General and Minister of Justice.
Unless there's another Attorney General. So if I say Godfrey Yeboah-Dame, obviously I'm talking about this Attorney General.
Yes, in his capacity as an Attorney General is the reason why people are getting to his office, not his person.
So this person is the person occupying the office. And I'm telling you that. You are saying, am I dissociating the man from the office? And I'm saying that the man in this office, since he became the man in this office, has not has not. You can't mention any single judgment death case that has gone against him in respect of international arbitration.
That's okay. We accept it. We accept it. But what has he done about this particular case since he assumed the office?
That's why I took my time to explain the law to you initially, that there was a final award. Arbitration, I explained to you earlier, that is where parties themselves willingly subject themselves to the arbitration. Now, arbitration is more or less the strongest form of dispute resolution, because it's the parties themselves that have submitted themselves to this particular process, even under mediation, which is less intensive as compared to arbitration. Even under mediation, when parties reach a settlement and the settlement is entered as final judgment, it's binding on both parties.
So we should direct our frustration to the Office of the Finance Ministry.